welcome to the Brennan Center for Justice and NYU School of Law. Please take your seats because we have a full evening and a rich topic to discuss. I am Michael Waldman. I am the Executive Director of the Brennan Center for Justice, and we are really delighted to welcome you here to convene this conversation and host this event. And we're really delighted to see so many people here, and it's plainly what Mitt Romney needed to do at Ford Field was have a really good topic and offer CLE. So that should be a lesson for his advancement. We're glad you could be here, and of course, as you know, we've got food and drink. The Brennan Center for Justice, for those of you who don't know our work or who haven't had the chance to visit with us before, is a nonpartisan law and policy institute affiliated with NYU that fights for reforms in the systems of democracy and justice. Our premise, which we shout from the rooftops all across the country on issues from voting rights to campaign finance to access to justice, is that if we don't fix our systems as a country, we won't solve our problems. And there are a few issues on which that basic premise seems more relevant than this. We were started, as you may know, by Justice William J. Brennan, the late great Supreme Court Justice's family and clerks, as a living memorial to him when he left the bench. And in fact, back there and throughout the office, you can see some of his memorabilia, which gives us a living reminder every day of the legacy we carry. And Justice Brennan did not want the Brennan Center to be some kind of copy of his own views on specific issues, but rather a way to carry forward his concept of living constitution and his deep belief that our justice system and our Constitution, above all else, should be devoted to the concept of human dignity. And we have, since the beginning of the Brennan Center's time, worked, among other things, on fighting for access to the courts and access to justice. We take our cue not only from Justice Brennan, but also as well from Judge Learned Hand's great statement and command that thou shalt not ration justice. And that is a driving value, a driving premise for our work. We've worked with so many of you here and around the country on fighting for the Legal Services Corporation, fighting against the debilitating restrictions and cuts that have made it so hard for so many Americans to receive access to justice. We fight and continue to fight for access to criminal justice and for criminal justice reform, including, among other things, the work that our colleague Thomas Giovanni and others do in the Community-Oriented Defender Network, trying to bring the model of holistic public defense around the country as a better way to protect rights and cure social ills at the same time. And given these concerns, given these values, we, as so many of you saw, a looming economic catastrophe and a looming legal catastrophe that very much spoke to this issue of human dignity. You all know, because so many of you work on this, about the thousands of New Yorkers and millions of Americans who face a crushing blow to their dignity when they are lured into mortgages that they often could not afford, when they are finding themselves caught up in the machinery of a justice system and a foreclosure crisis that is so big and so much bigger than any of us as individuals. You've seen the ripples throughout our community and our country and our economy. And you know, too, that this is not only an economic crisis, but a legal crisis. The Brennan Center got involved in this a bit a few years ago with a report that we did looking at the lack of legal representation for so many people in foreclosure procedures. At that time, we published data showing that 6 out of 10 families facing foreclosure lack a lawyer. I know that there is even more troubling and more recent data in New York that 67% face foreclosure without legal representation. And it is our belief, and I know the belief of many here, that making sure that everybody has adequate representation or help is not only good for those facing foreclosure, but good for the system, good for the lenders, and good for the economy as well. There are so many people doing so much work on this. So many of the leaders in this field are represented here tonight. We want to thank those of you who work in this area, from legal services, from the private bar, from the financial industry, from Attorney General Schneiderman's office, an Attorney General who once again has shown true leadership for New York State and the whole country, and widely recognized as such. And I'm going to turn over the mic to my colleague, Mark Ladov. Mark is a counsel at the Brennan Center. He came to us, among other things, from career in the law at the ACLU, but of greatest relevance with Queens Legal Services, working on the front lines of the foreclosure crisis. He works on our justice issues here, as well as on another catastrophe, the aftermath of Citizens United. So we keep him plenty busy with interesting work. But I'm really delighted, Mark, that you are here, and glad to hand the mic over to you.
I'll take that. Thanks, Michael. As Michael said, I was at Queens Legal Services. I promised that this event was not simply designed to bring everybody I used to work with into one room at one time. I'm thrilled by the huge turnout we've had here. Obviously, it speaks to the depth of this crisis and the interest in this issue, and we have a lot to say tonight. Just a couple of very quick housekeeping issues. If you're interested in CLE credit, you should make sure that you signed in on the way in, and make sure that you sign out on the way out. I also do want to thank, obviously, Michael and the rest of the Brennan Center's management for their leadership on this issue, for fostering an environment where we can really tackle these issues with the effort that it deserves. I want to thank everybody here who helped out with this event, especially Emily Harrison, Nita Paul, who did a lot of the administrative work to make sure that this all went smoothly. Nita has also done a lot of great work on our foreclosure policy work, including a series of blog posts in the Huffington Post that hopefully everybody saw over the past month. So I just want to cut to introducing this panel very briefly, and I think we have, I think everybody's going to be mostly interested to hear what they have to say. Ingrid Gould Ellen will start us off. She's the professor of urban planning and public policy at NYU's Wagner School and co-director of the Furman Center for Real Estate and Urban Policy. She's the author of Sharing America's Neighborhoods, the Prospects for Stable Racial Integration, among other publications. After that, we're going to hear from Josh Zinner, who has been a leading advocate on predatory lending and abusive lending and foreclosure issues for more than a decade. He's currently co-director at NEDAP. He's worked at South Brooklyn Legal Services, at Legal Services for the Elderly, and before that as a social worker, primarily with the homeless. We're going to hear from Jose Perez, a New York City homeowner who's going to share his personal story about foreclosure. As you'll hear from him in more detail, Mr. Perez has faced the loss of his family's home in Staten Island. He's been able to save it with the help of Staten Island Legal Services. I think you'll hear his story is both unique, but also shares a lot of common threads about abusive lending practices and personal hardship that we hear in a lot of the foreclosure cases that we're struggling with in the city. After Mr. Perez, we're going to hear from Jay Inwald, the Director of Foreclosure Prevention Litigation at Legal Services NYC. He joined Legal Services in 2009, bringing nearly 25 years of complex litigation experience to the work of its citywide foreclosure practice, which now has more than 45 advocates representing homeowners around the city. And finally, we're going to hear from Scott Wilson, who is Senior Advisor and Special Counsel to the New York Attorney General, Eric Schneiderman, and I know everybody's going to be excited to hear what he has to say about the settlement, which we've all been reading about, as well as the investigatory task force. So let me turn the mic over to Ingrid, and we'll do this.
Wonderful. Well, thank you. Is this on?
It's probably not. And I should also mention for both panelists and questions, just to make sure to use the microphones because we are recording the event.
Okay, is that better? No? Okay, is that better now?
Yes.
Okay, so first of all, there are a couple seats in the front here, actually, for some of you that are standing if you want to choose to sit down. We do have some seats in the front row here. But I do want to say that, I'm delighted to be here at our sister NYU organization. My job is to provide just like a 5-minute, very quick, kind of 10,000 feet in the air overview of the foreclosure situation in New York City. I don't have eyes at the back of my head, so I'm sorry, it's a little challenging for me to follow this PowerPoint, but I'm gonna try. And, okay, that is the first slide. So, I mean, in most recessions, foreclosures spike a bit as people lose their jobs and can't pay their mortgages, and you can see that sort of in the gray bars here in the diagram. You can see a little bit of a spike every time, you know, and that we've hit a recession back to 1980. But the increase has been relatively modest, and in all cases, the foreclosure rate has stayed below no more than 0.5% of all outstanding mortgages in foreclosure, and this is the United States. This recession has been completely different. Yeah, I know. It's really unbelievable. So, you know, that just over the next between 2006 and 2009, the foreclosure rate tripled in the United States. And through the end of the recession, although you've seen it sort of foreclosures have kind of fallen off in fits and starts over the last couple of years. You know, it's not clear, we're still at a rate, first of all, which is more than double the rate we've seen, any rate since we've seen since the Great Depression. So even though things have come down a little bit, we still are experiencing a very elevated rate of foreclosures. And I think it's not clear exactly, I don't think this slowdown suggests that we're out of the woods. I think some of the slowdown may be due because, you know, some of the most toxic loans have worked their way through the system. But some of it is also probably due and some of it may be due to policy efforts to encourage modifications and perhaps, like, you know, monitor the foreclosure process a little bit better. And I think a lot of it just may be from sort of more caution from servicers who, you know, in the wake of various, you know, who are worried about lawsuits. So it's not clear that this necessarily means that homeowners are more stable in the United States. If you look at the picture in New York, I hope that's where I am. Yeah, you've seen sort of a similar pattern where we've seen, you know, we saw a dramatic rise over about the same period, and then we've seen something of a decline. Once again, you know, it's not clear exactly what is behind that decline. This actually shows the number of foreclosure auctions in New York City. You can see an even more precipitous decline. So last year there were just 246 foreclosure auctions in New York City, down from about 2,000 a few years earlier. And you know, and again, it's not clear exactly. I mean, I'd love to hear from the audience and sort of what some of the causes are for the decline. We're still trying to sort of figure it out exactly. I think a lot of it is due to process delays. This is not. You know, we've seen some fall off in the number of homeowners who are delinquent on their mortgages, but nothing that could explain this. So I think a lot of it is just you know, banks and law firms perhaps being you know, wary of actually going through foreclosure, of the additional requirements that it now takes to go through foreclosure, and you know, hopefully maybe some more success in getting borrowers into modifications. But again, we're digging into that right now. I can say that certainly the foreclosure process has been lengthening. I think we're going to hear a little bit more about the foreclosure process from some other panelists, but you can see the top line is New York, and you can see this shows the average days between a start of a foreclosure and an auction, in all the 50 states, going from 2007 to the end of 2011. And you can see that now we're getting close to sort of in New York that the mean is close to 3 years, so we've seen a real a real lengthening of that. Part of that may be backlog. Again, part of it is sort of explicit policies that have lengthened the process to sort of force lenders to actually to do more to prove that they have cause. And you can see that another thing is that I think that this lengthening of the process means that we can't just look at, say that, oh, we only had 246 foreclosure auctions this year. That means we no longer have a foreclosure crisis in New York. We still have a lot of borrowers that are distressed, and we have a lot of borrowers that are underwater. And what this shows you is about 40%. I think you hear a lot about underwater borrowers in Phoenix and Las Vegas and Miami, but in fact, in New York City, we have a lot of borrowers who owe the bank more than their homes are worth. It depends a lot what borough, a lot of variation across boroughs. You look at Manhattan, nothing's happened in Manhattan. Manhattan it's been an island in this foreclosure crisis, which probably doesn't come as a surprise to many of you, but you can see in Bronx and the Queens, in Queens, about half of borrowers are, we estimate, to have negative equity, and if you look at particular neighborhoods like Jamaica, the share is even higher still. So, you know, another reason I think that we can't, we can't say that the foreclosure crisis is over in New York is that certain neighborhoods in New York are still being hit extremely hard by this crisis. So this shows you, you know, overall the foreclosures have been very, very concentrated in New York City, largely in sort of northern Brooklyn, southeastern Queens. This shows you the incredible concentration, and this shows you how correlated that concentration is with the racial composition of those neighborhoods. So virtually all of the communities that have been hit hard by the foreclosure crisis are over 90% minority. And so I think that, and this just shows you one census tract in Jamaica, just to show you how many properties are affected by foreclosures in some small neighborhoods in New York. So I think this is something that we're going to be living with in some of these communities for many years to come, and I'm happy to talk later about a lot of the work we've done at the Furman Center showing not only the impacts, obviously, that this foreclosure crisis has posed incredible pain on individual homeowners and borrowers, but there also are collateral impacts on the communities as well. So I think I'll stop there for now.
So thanks. Is this working, this mic? Okay, now?
That's not good.
Maybe I'll have to check.
How about this?
Walk around in front the Donahue look. So I have 5 minutes, and there's a lot of points to make. So I want to just put out a few issues for sort of maybe for discussion later. There's certainly, as the map that Ingrid showed demonstrates, there is a very heavy concentration of foreclosure filings in communities of color in New York City. And this is no accident. These are the same communities that were heavily targeted for high-cost loans going way back. This crisis, although the foreclosure numbers are going up and up, this foreclosure crisis is nothing new in communities of color around New York City. Bed-Stuy, Central Brooklyn, Eastern Brooklyn, Southeast Queens, Northwest Bronx, and northern part of Staten Island, all across the city. These are neighborhoods that have been targeted for many, many years for abusive and predatory loans, and there's a heavy concentration there. And these are the same communities where there's a heavy concentration of foreclosures going back many years. And this is part of a long legacy of redlining by the mainstream financial institutions, where they would literally draw lines around certain neighborhoods and refuse to lend to communities of color, so that there was a huge vacuum of affordable credit in these communities. And then into that void stepped abusive and predatory lenders and really targeted people for high-cost loans and gouged them. And again, this is nothing new. This really exploded, especially in the mid-90s, when Wall Street started securitizing or started bundling together subprime loans and high-cost loans, and they started making huge money off bundling together and slicing up bundles of these loans and selling them off to investors. So that suddenly there was a lot of money to be made, whether these loans were affordable or not. And you know, a common characteristic of a lot of these abusive loans was that they were unaffordable at their inception. And when these loans were sold off to Wall Street and securitized, it really didn't matter people were making money hand over foot regardless of whether these were good loans or not, and I don't have time to get into that process, but we can talk about that later. So there was no longer any incentive by lenders to make sustainable loans, and in fact, Wall Street was heavily marketing to unscrupulous lenders the need to just feed the securitization machine and make as many mortgages as possible, regardless of whether they were sustainable or abusive. And so you had this huge run-up by the trillions in high-cost lending, and a lot of these securitization trusts were really these houses of cards, were really built, many of them, on unsustainable mortgages, and when they all crashed, it led to, of course, the wider economic crash, and it really rippled out in profound ways. So the foreclosure situation now, Jay's going to talk, I think, a little bit about the reason why foreclosure filings are down and why auctions are down, but the numbers have really not gone down at all. In the packets, I think, that you guys received is at least excerpts of a report that NEDAP put out a couple of weeks ago. And using data that is collected from the banking department showing pre-foreclosure notices, we found that 345,000 were filed statewide last year. In New York City alone, 95,000 pre-foreclosure notices were filed. Now, in the materials is a map that shows that these were heavily concentrated in the same communities of color that have been, right, it looks exactly like this. We're heavily concentrated in the same neighborhoods. So while foreclosure filings are down for, and if, Jay, are you going to speak to this?
I will not. No problem. I can do it in my sleep.
I will say, in short, a lot of it has to do with the fact that the lenders can't get their paperwork together and really can't establish in many cases that they have the legal right to foreclose, and it's really slowed up the process. We can see from these numbers, pre-foreclosure notices, that mortgage distress, the people at risk of foreclosure, is continuing to escalate. There's a couple more themes I just want to throw out, and then we'll move on. One is regulatory failure. I think it's something just to put on the table in our discussion. This didn't happen in a vacuum. It didn't, again, there were, as we talked about, lenders made trillions of dollars in loans, many of which really loans which shouldn't have been made, and really heavily marketed abusive loans, particularly on people of color, but on people around the country. And this happened in a regulatory vacuum. And this is bipartisan. This happened across, it started in the Reagan administration, in the Clinton administration. They blew up Glass-Steagall, which was a Depression-era law that separated banking from speculative activities by financial institutions, and that really helped lead to the crisis. So it was bipartisan, and then, of course, in the Bush years, the deregulation continued. And there was just this attitude of the market will correct things, but this was not a market that corrected things. This was a market that really there was a strong incentive, again, to make abusive loans because people were making lots of money off of them. So there was a complete regulatory vacuum, and perhaps best personified the Office of the Comptroller of the Currency, which is the supervisor of the national banks, the big banks, Chase and Wells Fargo and Citigroup and Bank of America. Not only were they not addressing this problem, but when states like New York passed strong anti-predatory lending laws, the OCC actually wrote regulations in 2004 to ensure that their national banks that they oversaw didn't have to comply with state anti-predatory lending laws. So actually went out of their way to ensure that their banks could engage in business as usual. And this is sort of symbolic of the complete regulatory failure that led up to the crisis. So just to put that on the table. And then, the other thing to put on the table is bank accountability. The banks talk a lot, or the lenders talk often about moral hazard when they talk about, well, borrowers shouldn't get too good a deal. Their principal and their loan shouldn't get written down because then everybody will go and default on their mortgages so they can get a good deal. And they talk about moral hazard, incentives to do irresponsible things. Well, the banking industry really that's the greatest moral hazard of all, because the banks engaged in heavy speculative activity that brought down the economy. and then got bailed out. And people have heard about TARP, and there's hundreds of billions of dollars there, but the taxpayer bailout really went into the many trillions of cheap loans through the Fed, and in fact a Bloomberg report that came out in the last couple of months, where they did a Freedom of Information Act request, they found that over $7 trillion in cheap money was given out to the banks after the financial crash. So there were no strings attached to this money. It wasn't given so that banks could provide credit to neighborhoods or to small businesses. There were no strings attached. So just to put that on the table, because as we move forward in trying to push to restructure our financial system so this doesn't happen again, and as we move forward to try and find ways to keep people in their homes and prevent this escalation in foreclosures, many of the biggest banks have pushed back hard against these efforts and have put millions of dollars into lobbying against them. So there's some real issues there. And Scott's going to talk a little bit later about the AG settlement. So I'm going to stop, but I just want to put some of those issues on the table for discussion later.
Hello. Hello? Hello? Yeah. Hello. Can you hear me? Well, my name is Jose Perez, and I bought a home in March of 2007. I thought I had done everything I was supposed to do to purchase this home. I went to a place called Neighborhood Housing, and I took some courses, on how to purchase a home, how to negotiate for a loan, and to get the best rates. But I guess, there were people better equipped than I was. I hired a lawyer, I had everything going for myself, but a week into buying the home, the house flooded. So here I was, I have invested all this money into this home, and I was underwater. My boiler was half underwater, so I was like, it's a week into this house now, and I'm saying, I cannot believe this is happening. So I figured, hey, you know what, I took this course. They told me, hey, contact the bank, let them know if there's any problem, the banks will take care of it, And I did. I immediately called the bank, and I said, listen, I have a major problem here. I just finished purchasing this home, and my house is completely flooded. I have a newborn in the house, and I don't know what to do. They said to me, don't worry about it, give us a call. I called them back. Somebody else picked up the phone from some other state, and I said, hey, I spoke to so-and-so. They didn't know who so-and-so was, and I said, oh boy, here we go. And I kept getting the runaround, and I got desperate. So I went to all my life savings. I went to my pension, because I work for the UFT, and Board of Education. And I said, I'm going to try to save my house. But I had to move my family out of my home because my house was underwater, it was cold, and I was running into a major dilemma because now I had to pay the mortgage, plus I had to find a place to rent. I contacted FEMA. FEMA came by and they said, this is a mess. You need to get out of this house. There's mold. You can't live here. And I said, I just finished investing all this money in this home. Now I have to leave. And he said, yes, you have to leave because it's endangering your family. So I moved my family out. I rented an apartment. Now I was paying rent and the mortgage and contacting the bank. And I was using every fund I had to try to repair this house, to try to move back in. FEMA assisted me somewhat. They gave me about $3,700, but the damage was over $40,000. So now I was stuck with this house, this $40,000 bill, plus this mortgage, plus this apartment, and didn't know what to do. I couldn't go to work because I had to try to take care of this as fast as possible. Again, I was trying to calm my family down, making sure my wife was okay. She had just finished giving birth. And I tell her, listen, we'll work this out, we'll figure it out. I contact the bank. Months went by, nothing. I contacted neighborhood housing. They told me, you know, you need to go speak to a place called Legal Services, Staten Island Legal Services. I said, okay, I'll try anything at this point because the bank ain't talking to me. Moving back into the house after I fix it, and you know, I was supposed to file something to get reimbursed, but when you're going through all this, there's no time to think. All you have to do is try to get your family back at home. But I contacted the bank, they wouldn't accept my payments. And then they said, you know, we can't accept your payments, you know, you've been late. And I said, well, I've been trying to contact, I told you what's going on, what the problems are. And they basically ignored me. There was no communication for months. And I wrote them letters, everything was certified. Somebody was signing them, sending them back to me. I contacted Legal Services. I met this attorney by the name of Joseph Sands. And this guy looked like he just came out of college. And I said, oh boy, this is gonna be interesting. This guy looks like he's still wet. You know, I said, I don't know about all this. And he says, don't worry, I'll contact the bank. I said, you good luck. I said, I've been trying to do that for a while. The guy contacted the bank, and he said they responded. I was like, I am listening to you now, because you have done something that I've been trying to do. He said, hey, we're gonna go talk, you know, we're gonna try to see if we can get a modification. I said, this guy's dreaming. You know, these guys won't even accept my payments. He's talking about modification. I didn't know what a modification was to begin with. I thought I had good credit, but since the late payments and everything started affecting my credit, so I couldn't get a lot of things that I needed to get to just get the house livable. But Legal Services came through. They said, hey, we're going to court. We're going to get something done. I thought that the flood was a bump on the road, but it turned out to be a nightmare because everything else fell in. And at this point, Legal Services fighting for me in court, and I'm just stunned because, you know, I had run out of money. I had no other choice. I was gonna be homeless. I was like that person in Titanic playing the instrument, telling the family everything's okay. But it wasn't, because I knew for a fact that I was gonna be homeless, but I just kept saying, it's okay. Everything will work itself out. I didn't know how it was gonna work itself out, but Legal Services was working on it. You know, I kept stalling, telling my wife everything's okay, you know, nobody, you know, relax. But I knew that I was sinking quickly. And finally, we get to the modification, and you know, we applied. They said that they denied me because I didn't communicate with them. And I said, I have all these certified letters. Here's, I laid it out right in front of the judge, and I said, Your Honor, these are all my certified letters. Somebody signed them in their office. I don't know which office it's going to, but it's going to the one that the address stated. Nothing. We waited, months went by, and I was like, I was losing hope already. I was like, well, you know, I was already planning in plan B because I was gonna be homeless, and food was running short. I got sick in the process, and getting sick, it devastated my entire family because I couldn't work. I couldn't do anything. I basically was in the hands of Legal Services. And, you know, they worked something out, and I was impressed because they got a modification, but it took so long for them to negotiate with me that it went to $111,000 over what the mortgage was worth. And at the end of the day, when they got me the modification, I owed more than the original loan, plus another $111,000 separate. I stood there speechless, but I had a home. I said, I got a roof over my head. You know, I'm gonna die before this loan is paid anyway. Because, you know, I got sick in the whole process. So, you know, I said, hey, I'll live however long I could live. and then, let somebody else worry about them. But, thank God, Staten Island Legal Services worked something out with the second mortgage, and they were able to get a payoff. But I still ended up owing more than the original loan, plus the money that I was paying them towards the mortgage while this crisis was going on. And the problem is that, we try to do everything, I did. I tried everything that you are supposed to do, supposedly. I took this course to train me to do this, and there was nothing that I could do to change the outcome. The homeowner didn't disclose a lot of the things. The banks did not communicate with the person that owns the home, and they basically left me out there by myself. And if it wasn't for legal services, today I would have been homeless. A family of 6 would have been homeless. And thanks to them, I couldn't thank them enough, because it's difficult.
So I should never have agreed to talk after Mr. Perez. That was a mistake. I think Mr. Perez's story demonstrates a lot of the themes that really pervade doing this work out in the field. So I'm, like Josh, I'm going to try to just touch on a few themes that I think is important to get out there, and I hope we'll get back to some of these during the more unstructured part. The main point I want to make is that foreclosure in New York is a lawsuit. It's a litigation, it's an adversarial process, and these are complex cases with complex facts, complex claims, and complex defenses that nobody could possibly navigate without help, without an advocate. And I think it's so important that the Brennan Center has chosen to get involved in these issues, because it's an issue of justice and due process and fairness in our judicial system. So I thank the Brennan Center for sort of making this part of their agenda. Also, just to give a little bit of background, the process in New York has changed over the last few years. It was largely, for years, a rubber stamp process, where there was just no involvement in the affected homeowners whatsoever. And that functioned kind of like a petri dish, which allowed an environment that was hospitable to the development of servicing abuses and foreclosure mill law firms that process literally thousands of cases at a time and practice law in a way that's not really recognizable to people to most practitioners. When lawyers started getting involved in the process, everything that's now front page news started getting attention. The Attorney General's office started getting involved and looking at a lot of these things. You've all heard about robo-signing. It's done both by servicers to generate the documents that are needed to establish, or at least purport to establish, the right to foreclose. It's done by foreclosure mill firms who act on behalf of MERS, which is Mortgage Electronic Registration System, on both sides of the deals to paper these supposed assignments. And none of these individuals have any personal knowledge, really, of anything that goes on, and there's almost no human involvement in the whole process of initiating a foreclosure action. Anyone who's sat through a deposition in one of these contested cases and sees how these cases actually get initiated, it's just sort of shocking. Our judicial system has reacted to this in a few ways, and in fact, Josh mentioned the issue about there being sort of a backlog of cases, so I might as well just mention that here now. It's a peculiarity of practice in New York, and it puts me at risk of really getting way too wonky and talking about incredibly uninteresting stuff. But there's a disparity between how cases are reported. There's not been that much of a drop-off at all in the filing of foreclosure actions. What there's been a drop-off in is the filing of requests for judicial intervention. That's a particular piece of paper that plaintiffs have to file in order to get the case assigned to a judge and to start the settlement conference process that we have in New York. It's those RJIs that are not getting filed. The reason those RJIs are not getting filed is because in response to the robo-signing scandal, our judicial system imposed a requirement that the filing of those forms be accompanied by the filing of a lawyer's affirmation. It's kind of shocking that this would be necessary in the first place. It doesn't require much of the attorney filing the case to fill out this affirmation. It requires them to basically say they've looked at the papers, they've reviewed the papers with a representative of the client, and in fact there's a basis for this action. It's hard to imagine that lawyers would contemplate filing an action in court without doing that, but in fact it's been virtually impossible under the model that the foreclosure mills use to actually comply with that requirement, because those complaints are generated without any human contact whatsoever, and there was nobody for them to actually review these with. So that's why we have these different numbers reported. There are actually almost the same number of cases actually filed. The problem is they're all stalled in the courts. The RJIs have not been filed. My colleagues here at MFY actually have documented this in a report, and they actually have a lawsuit about that. I want to talk for a minute about the settlement conference process, because there are a lot of challenges with that as well. That's a complex process, and Mr. Perez sort of talked about that, touched on that. You really can't expect the process to work if you don't have representation. It's a process in which the lenders are always represented by counsel, and the idea that you would send homeowners into that process and expect something constructive to happen can't really be taken seriously. Again, you may have heard some numbers have been thrown out there about the relatively low numbers of actual settlements achieved at the settlement conference process, but I would posit that that's largely a function of the high percentage of people who don't have counsel representing them at the settlement conferences. Many people in this room are at legal services and legal aid organizations where we have very good track records at the settlement conferences, and we make them work, and we get modification agreements and other home saving solutions because we're advocating for our clients, and we make that happen. So New York did a lot of good things to try to address the process. It created a settlement conference process. It enacted foreclosure, consumer protections, and as part of those protections, the state actually funded a network of housing counseling providers and legal services providers doing the foreclosure prevention work on the ground. The availability of those services has done an enormous amount to make the foreclosure crisis in New York a lot less bad than it would have been, and a lot better than it's been in a lot of our peer states. Unfortunately, we're on the precipice of losing that entire network because the proposed budget for the coming year eliminates funding for that program entirely. So I think it's really important that if people want to do something to address the crisis, people can express their views to their legislators and make it known that this is not the right time to be pulling the rug out from under this program, which has been incredibly cost effective and has actually helped New York weather the crisis a lot better than others. As I said, the conference process is far from perfect. There's talk now about additional initiatives to try to make them more meaningful. It's a huge challenge. Anyone who's there on a day-to-day basis knows that for the most part the lenders are represented not by someone with any kind of settlement authority, but by foreclosure mill firms, perhaps not even employees of those firms, but per diem lawyers who have no knowledge of the case and no relationship with anyone at the client and no ability to even contact someone with decision-making authority. Judge Lippman has announced an initiative to make the conferences more meaningful which I applaud, by having servicer-specific parts where there's going to be a representative of particular servicers on particular days of the week. It's a great idea, but I have to say, for that to work, clients, homeowners need advocates. It just is not going to happen with them alone in a room without someone advocating for them. So, again, I think I'm way over the 5 minutes I was supposed to talk about, so maybe I'll hold off. There are some substantive issues that would be great to talk about, but I don't do 5 minutes very well, so let me pass the mic along.
Thank you. Good evening. I wanted to thank the Brennan Center on behalf of the Attorney General's Office for inviting us to speak. After hearing so much about the problems, I should preface all of the following by saying that the settlement that's just been announced is not a panacea, and certainly the $25 billion or so in monetary relief that come with it is a drop in the bucket when you think about the $700 billion or thereabouts of negative equity in this country. That's the gap between the value of the home and the principal balance of the mortgage, as the professor referred to as the underwater part of the mortgage. But it is going to have, I think, some real and valuable and important benefits to homeowners and borrowers throughout the country. So what I wanted to do, and the settlement has not been filed yet in D.C. District Court, which is where it's going to be filed. So unfortunately, both now and if we have questions, I'm a little limited in what I can say, but I want to talk about three key parts or elements of the settlement that I think are very relevant to what we're discussing tonight, and then forth a little bit about what's not in the settlement and what remains to be done. The first part of the settlement, which, as you may know, was negotiated by a coalition of about 50 of the state attorneys general around the country, including A.G. Schneiderman, as well as the Department of Housing and Urban Development, the Department of Justice, and other federal agencies, with 5 banks, several of which are national banks. You've got Bank of America, Citi, Chase, Ally, and Wells Fargo. One of the things the settlement is going to do is impose a set of uniform and nationwide standards for the conduct of not just foreclosures, but also interacting with the borrower leading up to foreclosure. There are all sorts of rules that are going to come as part of this, including requirements that the servicers notify borrowers of their loss mitigation options that are out there, either proprietary or federally available programs, give notice to borrowers before referring them to foreclosure counsel. There's going to be restrictions on dual tracking, which is the process of moving someone towards foreclosure while they're talking to their bank about obtaining a loan modification. And then there will be requirements that the bank provide a single point of contact so that the borrower does not have to call back and speak to 6 different people, hopefully. I would exhaust all of us if I tried to list all of them. It's very long, it's very detailed. I can refer you to a 10-page summary that's on the national website for the settlement that's already been published, which one can find. I don't remember the address, but if you Google National Mortgage Settlement, you'll find it easily enough. The actual standards are longer, they're very detailed, and they'll come out soon. And as I said, again, these will be, it's not legislative, it doesn't apply to everyone, but it's nationwide and uniform in application for all of the servicers that are part of the settlement. This obviously begs the question of compliance, and which is an important issue. And I want to emphasize that the way this settlement has been negotiated is it's going to be, the standards are going to be part of a consent judgment that the servicers agree to, and which will be submitted for approval to a federal district court in Washington, D.C. Once the entire settlement, the consent judgment is entered by the court, it has the force of a court order, and the court will retain jurisdiction to enforce it going forward. In the first instance, compliance by the banks with the servicing standards and other aspects of the settlement will be overseen by an independent monitor. That monitor will have resources available to him. It's Joseph Smith, the former banking commissioner of North Carolina. he can employ attorneys, auditors, professional staff to aid him in evaluating, sort of first cut, the conduct of the bank and their compliance with these new standards. The monitor will report both to the federal court, which will retain jurisdiction throughout the settlement, and to state and federal authorities, including the state attorney general. And in the event of violations, those government authorities will have the sort of pre-established right to go back to that court and seek redress for those violations. In particular, the court will have the right to impose significant and escalating financial penalties in the event the banks fail to remedy violations of these standards. Moving from the standards, sort of conduct going forward, the second large element of the settlement is what's sometimes referred to as a menu of about $20 billion in monetary relief. It's called a menu, or at least that's how it's been referred to, because it provides for a long list of types of consumer relief, from principal reductions where, as we've heard, the balance of the mortgage is reduced to something more sustainable, to refinancing, other types of loan modifications, and other types of homeowner assistance like forbearance during periods of unemployment. And the banks collectively, the five who are part of the settlement, have committed to earning $20 billion of credit by giving these types of relief to borrowers throughout the country. Not all of the activities for which they can earn credit will earn them dollar for dollar credit. So, for example, for some activities that may involve $1 worth of relief, they would get cents on the dollar, some number of cents on the dollar in terms of credit. That's why, and it can be a little confusing, you may have heard the Department of Homeland, not Department of Homeland Security either, Department of Housing and Urban Development, I knew I was going to get it, have estimated that the $20 billion in credit that the bank has to earn on its side might add up to about $40 billion in actual consumer relief in terms of the dollars that are seen on that side of the fence. HUD estimates, for example, that New York borrowers, and as we were reminded, although we don't have a high preponderance in the country according to the CoreLogic negative equity reports, we do have, particularly here in New York City, a significant number of underwater borrowers. HUD estimates approximately $495 million of this relief will flow to New York borrowers. The thing I want to emphasize about the $20 billion, which is important and critical, is that it places a real priority on principal reductions for underwater borrowers. At least $10 billion, that $20 billion is going to go to principal reductions, which of course help yield lower monthly payments and allow people who were previously underwater or more underwater to refinance or sell their home. And the settlement will also place some limitations on what types of principal reductions the servicers can get credit for, with a view towards making these sustainable mortgages post-modification. Others on the panel are more expert in the inner workings of HAMP than I, but I will note that although principal reductions are one of the forms of relief that HAMP tries to incentivize, this is the Treasury Department's program to incentivize banks to get loan modifications, it certainly doesn't prioritize principal reductions, balance lowering. And there's a growing consensus that principal reduction is the way to go. The principal reduction is going to be a central part of the recovery of the housing market, and we really think that this settlement is a significant step in the direction of making principal reductions a standard for the industry. In addition to the $20 billion that is principally goes to current borrowers, although there are community blight, I want to emphasize it's not entirely just for current borrowers. There is also a fund of approximately $1.5 billion, not approximately, of $1.5 billion that'll be used to fund payments to individual borrowers who were foreclosed upon between 2008 and 2011, and in the process were victims of improper foreclosure practices. This is the payment that's been reported of maybe $2,000, $1,800 a borrower. The reason you're hearing approximate numbers, as it depends somewhat on borrower response. Obviously, that amount isn't going to compensate everyone for the harms they might have suffered as part of the foreclosure process, but anyone who takes that money who's eligible doesn't have to give up any legal rights in exchange for it. And so if they wanted to bring a case, maybe as a class action, they would still be able to do so. The third element, and closest, I think, to what we're discussing tonight, and most important in a way, is a $2.5 billion fund of what I call hard cash, as opposed to the sort of soft dollar commitment of the $20 billion, which will come in the next year or 2 years. This is cash that state attorneys general can use to fund housing counseling and legal assistance programs for borrowers and other consumers. And Attorney General Schneiderman places special importance on ensuring, as Jay was saying, that people who go through this process have access to legal representation. And he successfully negotiated a package of more than $100 million in cash for New York. Many of the organizations that provide those services I know are here tonight, including on this panel, and we've been talking certainly to LEDAP and Empire Justice and others about the best and most efficient way to get these funds where they need to go. We welcome your input. We look forward to continuing those conversations. And I wanted to single out my colleague Mike Mead at the back of the room, who's been part of those conversations, and please talk to any of us afterwards about that. We also expect and look forward to working with your organizations in terms of educating borrowers and other members of the public about what relief they may be eligible for under this particular settlement. Finally, I promised to say a bit about what's not in the settlement, and what I was referring to is the absence of any broad grant of immunity to the banks, these 5 banks, for sort of all misconduct relating to the mortgage crisis. This has been a sort of key part of the negotiations, in particular for Attorney General Schneiderman, who's long and strongly objected to any general release as part of this settlement, first alone and then joined by a sort of growing chorus of organizations and other officials who objected to any sort of amnesty. As a result, while the settlement does release the banks from state and federal from some civil claims relating to servicing, foreclosure, and origination conduct, it really preserves a wide array of claims, in particular relating to the securitization of mortgages to which Josh referred, which is the process of pooling mortgages into trusts, and then those trusts issue bonds to investors, including investors like public pension funds. To just give a few examples of areas of legal claims that we and other state attorneys general and feds would be able to pursue even after this settlement, and I want to emphasize that this is not an exhaustive list, but this is a public list. Claims based on misconduct and securitization of mortgages, as I mentioned, including securities fraud, criminal liability for any conduct by anyone anywhere. There's not a criminal release to be seen as part of this settlement at all. Claims against the private national mortgage electronic registry system, better known as MERS, as well as claims that our office has asserted against various financial institutions for deceptive and fraudulent foreclosure practices involving MERS in a lawsuit we filed earlier this month in Kings County Supreme Court. Claims that, to lawyers, this is, I hope, obvious, but we can't and didn't release any claims on behalf of individual homeowners and members of the public, so certainly borrowers and other consumers, whether individually or as part of a private class action, can continue to assert their own rights. And claims under state grant limiting laws are also preserved as well. As part of pursuing these claims, President Obama announced during the State of the Union address the formation of a new task force, which has taken the form of the Residential Mortgage-Backed Securities Working Group, created by Attorney General Holder a couple weeks ago. The working group is co-chaired by Attorney General Schneiderman on the state side, along with the chiefs of the civil and criminal divisions at the Department of Justice, the Director of Enforcement at the SEC, and the U.S. Attorney for the District of Colorado as a representative of the U.S. Attorney's offices. And this group is tasked with investigating fraud and other misconduct, including things not released by the current settlement. There are significant efforts underway to marshal federal and state resources and bring those to bear on these investigations. As was publicly reported, there was a meeting held just a few weeks ago in Washington to discuss mortgage securitization cases hosted by the SEC that drew out actually literally hundreds of lawyers from Justice, the SEC, our office, agency investigators from FBI, the IRS, and all sorts of other places. I'm not going to be able to answer questions this evening about ongoing investigations, but I can say that the scope, the narrow scope of the releases in the national mortgage settlement have preserved a broad field of investigation and enforcement work, and we and others are deeply committed to pursuing those cases. So I will thank the Brennan Center again for inviting us to participate, and I look forward to answering your questions.
Thanks. So maybe to start things off, I wanted to try to tie in some of what everybody said together with a question about incentives. You know, when I think about an ideal mortgage market, I always sort of have this image of It's a Wonderful Life in my head. Jimmy Stewart's there as George Bailey running the community savings and loan. He's lending money to people in the people in the community to buy their first home. But you know, he as a lender benefits because homeowners are able to make their payments on time. They're able to succeed in their homes and you know, give him the return that allows him to lend more money to the community, et cetera, et cetera. And it feels like we live in a world where these incentives are all really out of whack from start to finish. So, as Josh mentioned, the securitization process, we have a system where, I mean, anybody who's worked with homeowners and worked with people kind of who were victims of predatory lending, you see these loans come in that were just obviously unaffordable from the very outset, and yet there's a financial incentive for somebody to make that loan. And for it to appear like a good investment on paper in the securitization process. When you get to the legal process that Jay was talking about, it feels like we have incentives where the servicers and the foreclosure attorneys have incentives to kind of push these cases through, even where obviously it's not in the best interest of the borrower, but where it doesn't feel like it's in the best interest of the lender either. And then at the modification side, again, it feels like it's too hard. It's harder than it should be to get people into modification agreements that allow them to get back on track, pay a return on that loan, and something that would benefit both the homeowner and the lender as well. And so I was wondering if you guys could talk a little bit about, you know, what are the incentives that we need to fix in this structure, and then how do we do that?
Yeah, I mean, I can start. I mean, you talked about two types of incentives. One, you know, one of the big problems in when all of these abusive loans were securitized, were pooled together and sold off as mortgage-backed securities, is even though there was a lot of junk in those securitization trusts, they came out on the other end looking clean as AAA rated securities, and under securities law, AAA rated securities are the most profitable. Those are the securities that pension funds and mutual funds and big state investment funds or you know, the big institutional investors are gonna purchase. And so there was a huge amount of money to be made off of bad mortgages, and the reason is because they appear to be good mortgages, right? So there's a real problem there. I mean, we do need a secondary market, and securitization of mortgages is going to be part of that no matter what. But there needs to be a way to fix the due diligence, the policing of how those mortgages are rated. Because that was really where the big failure came in. There was sort of mortgage laundering going on. That the system was able to turn bad mortgages into AAA rated securities, and that was a really fundamental part of the problem. So because of that, it was very profitable to make bad mortgages because you could sell them the next day by the hundreds of millions. And so that's something that needs to be really fundamentally fixed. It was the credit rating agencies that were Moody's and Standard & Poor's and Fitch that were really fundamentally involved. They were the ones that rated these as AAA rated securities, and there was the incentives were all wrong there. They've made their money from the issuers of these securities, from the investment banks that were putting the pools together. And so if they weren't rating them AAA, then the investment bank would just go to the next one. So they had every incentive to look the other way, and that has to be fundamentally changed. Unfortunately, the Dodd-Frank, the big financial reform law that passed last year, came up a little short in terms of really regulating the credit rating agencies' So there needs to be a lot more work to be done in holding accountable sort of all the players in the securitization pool, and maybe Attorney General Schneiderman's investigation that really digs deep into how all of this happened will you know, that maybe that will help to solve that problem. As in terms of servicer incentives, and I'll brief here, but there's really a fundamental problem also with in those securitization trusts. The servicers who are contracted by those trusts make more money foreclosing than doing loan modifications. Loan modifications take time and money. With foreclosures, the servicers make all sorts of fees off of the foreclosure, so there really is a financial incentive for them not to do modifications. And that is certainly one of the problems that's leading to sort of all of the problems that we're seeing in getting modifications when they should be happening. So that also needs to be fixed. I don't know if others want to.
Yeah, I would just jump in and say, I mean, first of all, I agree 100% with everything Josh said, and I would just further that, I mean, on the servicer side, you know, I think that's, you know, HAMP was really trying to go after those incentives, and I think, but I think probably didn't go far enough. I think has been, we can talk maybe more about it, I mean, has certainly been moderately successful, but I think it turns out those servicers' incentives were even more pernicious and screwed up than I think we really had imagined. So I think there's more work to do there. And you can see there's a lot of variation across servicers now in who's modifying loans, which is interesting. It suggests there is something there. And the only other sort of, I mean, sort of the incentives were wrong at every stage of the process. And the one thing I'd add to what Josh said is just, I think also the mortgage brokers were a big problem. And I think that if you look at any research that see the loans that were originated by mortgage brokers ended up going sour far more frequently than other loans. So I think that origination channel, I mean, that's an area where I think Dodd-Frank has done a lot more in addressing some of the most egregious practices on the part of mortgage brokers and some of those incentives. But I'm not sure we're all the way there. I think that's something to be concerned about too.
Maybe I'll seize on this to go off on a little bit of a tangent. Because we were talking about securitization, it brings up an issue in about the judicial process, which ties into securitization, which is in that, and it's also tied into the robo-signing, which is that in the large majority of cases, nobody can figure out who actually owns the loans that are being sued on. And there's a real due process problem in New York in our cases that we experience all the time, which is that at the outset of a case, it's virtually impossible to tell whether the plaintiff who's purporting to sue in foreclosure actually has the legal right to do that. And there's been some bad law about that defense, that defense that we in the legal community call standing. In other words, does this plaintiff own the legal rights that it purports to enforce? That defense is deemed to be waived in most circumstances if it's not asserted in response to the complaint in the answer or in a pre-answer motion to dismiss, which is in essence within the first 21 or 30 days after the case has been started. There's an easy legislative fix which would make it clear that that defense is not waived and that it can be asserted when the facts emerge that justify that defense. And that same proposed bill would also require the plaintiffs before they go into court to do their homework and get their paperwork in order and actually find the notes that they're suing on and make sure they're properly assigned to the parties who need to be to own them before they can go into court. So that's not necessarily incentive, perhaps it's coercion, but maybe we need a little bit of coercion and not just incentivization to make the process fair and not result in people potentially losing their homes to foreclosure to parties who haven't been able to actually demonstrate that they have the legal right to do that.
Do you think standing can be waived in federal courts? You talked about the state courts.
Well,
if you don't bring an objection to standing, it's waived. But in the district court, I don't think so. Well, they filed proof of claim in the bankruptcy courts, the challenge, and there's no waiver of standing in bankruptcy courts.
Probably not, because the law that has reached that conclusion is based on an interpretation of New York's procedural rules about which types of defenses are waived. and standing is on a different footing. This is way too legal for this audience probably, but for some people in the audience, but standing in federal court, standing, that's true, we're justifying the daily credit. Standing in federal court is a matter of constitutional dimension. So under federal rubric, you really couldn't view it as waived. It's because in state court, there's a notion that it's actually not a matter of constitutional dimension. They've been able to arrive at that interpretation.
Anyone can come to the state courts and claim.
They do all the time.
That's incredible.
So, you know,
Anyway.
so I think there's a question in the back, so do you want to, here, so we're just gonna, let's throw it open to some questions and these are working.
Thanks. That was actually a great tangent into the question that I had, and I volunteer for the Foreclosure Prevention Network, or the clinic rather, and I'm also a consumer rights bankruptcy attorney, and it seems to me like there's a really heavy emphasis on loan modification, settlement conference, loan mod, and I know that everyone's scared of the word bankruptcy and what that can mean, but I feel like there's such a bigger avenue and such a more friendly venue for debtors in that space, and there's such a better handle I think that the judges have on what's really going on challenging proofs of claim for the attorneys who are willing to do that. And so I'm wondering if perhaps the focus is a bit, if not misplaced, is not quite as focused on taking advantage of all of the opportunities that are out there that could really provide more help for homeowners.
I will never understand bankruptcy.
I mean, certainly bankruptcy is a good avenue often to address a lot of these, but you know, one reason why it's not as good an avenue is that you're not able to, in bankruptcy court, cram down or reduce the value of the first mortgage. So there was a real push for a number of years to change the bankruptcy laws, especially after the whole financial crash, that would have allowed you to go, a homeowner to go into bankruptcy court and if they were underwater on their mortgage and push down the value of that mortgage to the value of the property, and then would allow the judge unilaterally in bankruptcy court to modify that mortgage. If that had gone through, not only would a lot of homeowners been able to get help through the bankruptcy process and get their loans restructured in an affordable way, but it also would have created, we talked about incentives, an incentive for servicers to do modifications outside of the bankruptcy process. What happened is that the big banks pushed back really hard on that. And it was actually, that change in the bankruptcy law was a key part of President Obama's foreclosure plan when it was first announced. So along with HAMP, this modification program that we've talked about that has a lot of issues, there was also supposed to be these changes to the bankruptcy laws, which would have really been the sort of the stick that would have pushed servicers to modify loans outside of bankruptcy. And that, again, the big banks lobbied hard against that, and the administration backed off, and it didn't pass. So I think that's one reason why you don't see as many of these cases going into bankruptcy court, because there isn't a way to get a loan restructured, a first mortgage restructured inside bankruptcy. It's not to say that it's not a good venue in a lot of circumstances, but.
Well, because so many of these loans were subprime, and you have a lot of the 80-20 loans where you have a house that's more than 20% underwater, you have this second lien out there that you're able to do a lot with, perhaps not in a Chapter 7, but certainly in a Chapter 13. I just think if more attorneys and volunteers knew about that option, it could at least inform the way in which we're able to service the clients better.
Yeah, I think that's absolutely right.
Chapter 7, judges in Eastern District, Judge Dorothy started lane stripping in Chapter 7 cases. It's possible some of the judges are doing it, some of the judges are not doing it.
This is Elizabeth from MFY Legal Services. So I just wanted to ask the bankruptcy people, because I have a client who has declared bankruptcy, and we were getting close to getting a modification on the first mortgage, and now there's an automatic stay. So for us, sometimes it actually hurts us, even though there's a second loan that, yes, can be stripped. Now we're much further behind in the process because of the automatic stay. I mean, have you been able to overcome that, or, because I'm like about to get a modification and now the bank finds another excuse to be like, oh, sorry. Well, whatever it is.
Services will do anything to procrastinate,
So for
deny.
me, like, bankruptcy was actually really bad in that case.
Well, you can always shift the process to the bankruptcy forum.
just to that point, if it's a HAMP modification, you can go to the, as long as you give permission, the borrower can still negotiate their modification, and that is part of HAMP, and it's allowed within the bankruptcy court. My question for the panel, though, would be, there's a lot of talk, I heard everyone talk about borrowers underwater. Is there a concept now that if your house is underwater, that's a problem, that's a justice issue? People buy cars every day, the minute they drive it off the lot, it's underwater. I have a lot of stock that's underwater. How do you correct for these issues? Or is it, there's something to be said for someone honoring a contract entered in good faith on both parts and making those payments?
I'll just jump in quickly. I mean, I would say that I don't know that it's a justice issue right now. I'm gonna skirt that question for a minute and just say that it's a real economic issue because, and actually, there's lots of evidence that, you know, people are not ruthlessly and strategically defaulting in the large numbers that a lot of economists would suggest.
About 25%.
Well, you know,
And the way you look at it.
Depends on, I actually don't think it's that high, looking at these numbers, I'm happy to talk to you afterwards, but I think there's one estimate that's 20%, but there's a lot of reasoning to think that's overstated, so there's lots of research that suggests, the best research suggests, it's, you know, not that, some people do, but the numbers are relatively small. But if you have negative equity and you lose your job, you're gonna lose your home, right? If you have negative equity and you have to move for a new job, I mean, either you're gonna have to rent out your home and rent somewhere else, or you're gonna fall into foreclosure, right? Foreclosure results from, you know, it's a double trigger, right? You lose your, you know, you have an income shock, you can't afford to pay your mortgage payments, and you're underwater. So it is a policy concern, and there's lots of evidence that the loan modifications that are most sustainable are the ones that involve principal right now.
But for both of those situations, the best answer is a short sale. There's no need to modify it. You want out of the property.
Yeah, no, short sales it can be a great solution, but those are really difficult too.
Well,
Well,
first of all, they're very difficult.
I think Ingrid covered the points. I mean, I think keeping people in their homes is a justice issue. Obviously, not where they're not able to. But you know, again, the economics here make it impossible. People are frozen. I mean, people who are underwater aren't able to move for a job, and nobody's able to sell their house. And so, even putting that aside, the value judgment. It's a profound economic issue, but also this. I just have to say this and we can move on. But you know, I said it earlier. This notion of moral hazard that people are going to run out and default because you know, they want to get a piece of principal reduction. That's really nonsense. I mean, there certainly are a few people out there, but that's not a reason to shy away from a policy response that would really be effective in keeping people in their homes and also in unfreezing the housing markets. And you know, and I said it before, but when you're talking about moral hazard, you look at the moral hazard of the banks, especially the too big to fail banks, and it's staggering. They, you know, it is you know, taxpayers. The losses are completely socialized, and the gains are in the pockets of the banks. So. That's a much bigger moral hazard issue, and I think it's important with principal reduction not to you know, sort of jump into this rhetoric of moral hazard, but to look at what's effective for the economy and really keeping people in their homes.
And the only other thing I would chime in on that issue is it may not be that a justice issue is triggered by houses being underwater, but a justice issue is triggered if the process is fundamentally unfair and nobody has any trust in the judicial process. That's what's a justice issue. And the other thing, it's a policy issue. I mean, the legislature has rightly concluded that foreclosures are not good in general for the community at large. Not just the homeowners affected by foreclosure suffer, but the entire community suffers. Neighboring houses lose their property values decline, local tax bases decline. So there are a lot of reasons why we want to do everything that we can to prevent avoidable foreclosures, and it's not a matter of justice being triggered by the fact that things are underwater. It's about, is this good for the state, for whole communities to be ravaged by foreclosure?
Yeah, and of course there could be, I mean, origination issues too, that, you know, you had, if you look, I don't have the slide with me, but if you look at the variation of, in LTVs across neighborhoods in New York, I mean, there were a lot of neighborhoods, and it's the same neighborhoods that were hit hard, it's the same largely minority neighborhoods, where everybody was getting 100 LTV loans. Now, is that a borrower issue, is that a lender issue? My guess is that a lot of people didn't understand they were getting 100% LTV loans and didn't understand the risk.
And actually, I'm sorry, just for everybody, doesn't do it 100.
Oh, I'm sorry, I'm sorry. It's loan to value, so essentially people were getting a mortgage for the full value of their home when the standard is 80%.
And in fact, a huge percentage of people that are underwater in New York City are underwater for the reasons that Ingrid's talking about. People were targeted for property flipping scams where they were sold overvalued properties. And again, it was people in communities of color, and there was fraud, appraisal fraud, where appraisers were part of the scams and actually over-appraised properties sometimes by 50% or more, and then lenders gave out mortgages on those properties because they could sell them off.
In Jamaica, I think it was 2008, I was just looking at, something like the median the loan to value, the median mortgage that was issued, originated, had a loan to value of 100%, right? That means that half of them had loan to values over that amount, over 100.
I think you also need to address the contract issue that you brought up, where there's a huge disparity in sophistication between these parties, and there's also, you know, straight up deceptive business practices going on. And so you have these homeowners, they're not really contracting, they're not negotiating anything, they're being handed these products that they don't understand, and they're being manipulated into entering into them. So
yeah, and if we want to talk about the sanctity of contract issue, I'd point out we see an awful lot of permanent HAMP-mod contracts that servicers decide they'd rather walk away from. So I think that the sanctity of contract argument is something to be cautious about.
You know, I also wanted to mention, when I first started this process, like I said, I took a course, you know, and when I went to this, I went to the bank, I applied for a loan. They said, hey, you know, you still need a cosigner. I said, okay, fine. I saw this place, it said home loans, officers. So I said, hey, looks like a legitimate office. You know, it's full of people on the phone. And when I went into this office, I was very comfortable. You know, they offered me coffee, you know, they wine and dine me. And I was like, man, this is nice. This is better than the banks. You know what I'm saying? I was like, so when I went around, he said, hey, listen, you know, you need to go around, find a home, and then we'll talk about getting you a loan for the home. I said, fine, I will do that. I went around, I looked for a home. The realtor that I went to get the loan from, at this time I was not aware of this, but the realtor had some, no, he actually knew the home loan officer that was going to lend me the money. So they were basically working behind the scenes. And the person that evaluated my house was right next to the officers of the loan. So, you know, what I found strange was after all this, because at the time you don't really look at all this because you're so consumed into what just happened to you. But just recently, I went back to try to see if I find the loan officer. And the place is turned into a barbershop. And I stood in front of this place and I said, wait a minute, you know? And so I said, okay. I went on Forest Avenue, this is Staten Island. I went on Forest Avenue and I look at the realtor company that was in this place, it's gone. And I said, wait a minute. So I'm looking around and I'm driving down the street and I find a realtor company about 5 blocks away. It's the same company with a different name. It's the same guy in the picture. So I said, I'm standing there at the light and I'm like, I got taken. And I wasn't even aware of this. And I am pretty good at detecting these things. But I wasn't able to figure it out until it was too late. The thing that I found more interesting was the boss of the guy that was giving me the loan came out of the same place smoking a cigarette talking to this other guy. And I said, they were all in cahoots. Now, it's too easy for them to change names. And I wonder why they haven't investigated that. I mean, why are some companies so easily able to just disappear? You know, why can't there has to be a string attached. If you get a loan for somebody, hey, why did he get the loan? How and who? Because right now I'm looking at this place and I'm like, this is like fraud to the, I mean, this guy is the same guy with a different name. The name of the realtor company was Exit Realty. Now it's SS Realty. And I said, my God. And then I'm listening to, hey, homeowners take advantage. And I was like, I got taken for a ride because I try to do the right thing. But, they saw me that, hey, this guy doesn't know anything about what's going on. And they prey. They prey on people that, that have jobs, because I had 3 jobs. So they said, hey, he's making the income, he'll pay it.
So,
I don't know,
Scott, I know that you can't talk about ongoing investigations, but since you're sort of the investigator here, I don't know if you can say anything a little bit about, where you see the scope of questions that the state and federal authorities are going to be asking around that stuff right now.
I'm pretty constrained.
Yeah, and I sort of apologize.
No, not at all. Mr. Perez's attorney is welcome to call us and tell us everyone is going to work within their own jurisdiction. I hope and expect that we will see states who are sort of wrapping up their participation in the multi-state settlement, which has been, our office is pretty sizable. Of course, there are other states with large offices, but some states only have a few people who are really familiar with these issues, unfortunately. And I hope and expect there'll be some redeployment where those people will be turning to conducting the investigations in this area or areas that are preserved by the carve-outs and release. And certainly the feds are very focused on actively bringing both securitization cases and are also looking at FHA origination cases. So I think I'll just have to say more to come.
So I know that we're running a little bit low on time. I know that this gentleman had a question and I know Lynn had a question. So maybe if you guys can both ask your questions and then we can go down the panel, and I had a couple of things I wanted to ask to conclude.
Sure. My name is Ian Wilder. I work for HUD-approved housing agency. The opinions I'm about to express are mine, not theirs. I feel that the GSEs and HUD still don't get it to a certain extent. Fannie Mae and Freddie Mac are pillars of MERS. Why haven't they yanked those pillars? Right now, HUD's approving the reverse mortgage market to move the same way as the purchase mortgage market, which is going to put our elderly citizens in the same problem that we just had with the subprime. Sonny Mae in our own state has some of the most restrictive requirements for modifications that I've seen more than any bank. And if I'm not mistaken, Fannie Mae and Freddie Mac refused to allow their loans to be part of this $25 billion deal. That's half the market. I mean, those are just a couple of examples. There are more. I'm thinking, and I'm not necessarily talking about Mr. Schneiderman's office because I haven't mentioned that they've really been forward on this, but a lot of these other government agencies still just don't get it. What do we do to get them to get it? And the one other I forgot, Fannie Mae, and I'm not sure about Freddie Mac, allows dual tracking on their own modifications. I got a client in a trial mod who was served, and it's a Fannie Mae trial mod. What's with that? So if someone could explain to me what's going on with our government agencies, and by the way, I'd like to thank Mr. Zinner and Mr. Inwald because I'm on a lot of the lists they're on, and they've done a good job of explaining as much as they can over time to a lot of us, not just giving time here. So I'd like to thank what they've done for the community, and I'm sure there are a number of other people in this room without cards in front of them that I'm not aware of.
I was going to address the moral question, which I think has been adequately hashed out, so I'm just going to, I'll let you all move on.
Is there any talk, sorry, I don't need my, any talk about class action suits as a way of going after helping borrowers.
Let me speak a bit to your question. You know, and you may know this well, the GSEs, the government-sponsored entities, Fannie Mae and Freddie Mac, are these strange public-private hybrids which have in recent years been put under the tutelage or technically the conservatorship of the Federal Housing Finance FHFA. So HUD's ability, I don't want to address the relationship between HUD and the GSEs, but I would just note that FHFA is really in charge of the GSEs for now. We think it's enormously important that the GSEs consider these sorts of loss mitigation programs, and all I can say is that I think there's a building consensus around that, and I think that many of you in this room are helpful in advocacy in that sense, and no, those loans are not part of the $25 billion settlement, and they do make up a large part of the market.
Say one more thing on the GSEs. They're regulators, this Federal Housing Finance Agency that you mentioned, and when the GSEs were taken over by the government, the Federal Housing Finance Agency was created to regulate them. And there's some politics going on here. I mean, the Federal Housing Finance Agency is a huge player in this, because there's a vast number of the loans that are out there that are owned by Fannie and Freddie, the head of the FHFA right now, Edward DeMarco, is pretty reactionary in the way he views foreclosure prevention. His view is that he has a taxpayer mandate to hold on to taxpayer dollars, and so he's strongly opposed to things like principal reduction. He's not looking at the big picture, like how much the freezing up of the housing markets is affecting taxpayers. So he's taking a very narrow view, and the president put up for nomination Joseph Smith, who is now the monitor for the Attorney General settlement. He was the banking commissioner in North Carolina and would have been very good on a lot of these issues, and that would have made a big difference. But he was not confirmed. The Congress would not confirm him. And so there's a lot of politics going on here. So there's a real freeze going on, in particular with the Federal Housing Finance Agency, which is really adversely affecting foreclosure prevention efforts in a very big way.
This jogs my mind. The only thing I want to add is that a lot of this comes down to an argument about the economics of principal reductions. And the whole question, we talked about incentives earlier. One of the big questions of this crisis in a way is, why aren't the banks making modifications that are what's called NPV positive? That is, that would enhance the net present value of the loan, because it costs X amount to go through foreclosure. Forget the community effects, which is the literal cost of going through foreclosure costs X dollars, and if you could lower the balance by Y dollars, and that was less, and it becomes sustainable, and the person was no longer delinquent, why wouldn't you do that? One thing we haven't mentioned, which this is anecdotal, not on behalf of the office, I think is at play, is just sort of infrastructure and administrative.
Yeah.
I'm not always sure that these are rational decisions the banks are making so much as that people aren't getting processed in the right way. But in terms of either the banks giving principal reductions or FIFO giving principal reductions through the entities, one of the things we hope that the at least $10 billion or more of principal write-downs that will come through the National Attorney General settlement is that will create another body of empirical evidence about what principal modifications do, redefault rates, and will help aid the conversation about whether this is the way to proceed for the fee for mortgages and otherwise.
I guess maybe getting to the question about class actions, and I don't know, I mean, obviously part of the problem is, of course, that, and the Brennan Center has done a lot of work in the past on the restrictions on legal services funding, but, I mean, correct.
Right, well, I probably even shouldn't answer the question as a legal services corporation funded group. I can tell you that there are other groups that have done some class actions around various issues, around servicing issues, around enforcing aspects of HAMP. There are a lot of class actions involving investors, concerning the securitization trusts and deceptions about that. So there is some class action activity around it, but not done by LSC funded groups.
And I can also give a less sophisticated answer to the class action question. I think also the bankruptcy question, which is resources. And it's one of the things that we've been concerned with is that, I mean, certainly when I was doing this work, there weren't enough lawyers to handle every case that came through court. And then, to take a case into bankruptcy is another level of resources above that. And so, I think that, certainly to the extent that that's a solution for a lot of these cases, then, we need to be providing the lawyers and the legal resources and the staffing to get those people the lawyers that they need. And that's an issue about the state funding that we've been, working on, that everybody here has been concerned with this, as well as getting other people involved. Getting the bankruptcy bar involved on a pro bono basis, for example, things like that. I think that we'd love to kind of keep that conversation going after this evening to make sure that we are thinking about creative ways to tackle that problem. I mean, starting with the fact that we need to make sure that we're funding the legal services and the housing counseling network that we have in the state right now, and expanding that rather than allowing it to shrink going forward. I guess maybe the concluding question I wanted to ask is simply, we do have a lot of folks here who work on this issue on a day-to-day basis, but we also have people from the private bar and from pro bono projects and from advocacy groups, and I'd love to sort of hear each of you just kind of give the one thing that you would love for people to walk out of here thinking about that they could do moving forward to kind of have an impact on this issue. Yeah, pass it.
Did you want to say anything?
I got a lot to say, but I don't think I have enough time.
Well, I do also, and there's so many different things. I mean, I would just focus on the fact that, again, foreclosure is an issue of justice. It's a litigation, it's a lawsuit, and the process should be fair. That implicates substantive issues. I mentioned the standing issue. It implicates access to counsel and really ensuring that the process is fair. It implicates access to housing counseling services for negotiating and navigating the loan modification process. So this crisis is with us. We're going to be in it for years to come, and we need to make sure that we provide people the resources to deal with it. But that's my that's my takeaway.
So, and I would just say two things. I guess the first thing is just building off my presentation is and some of the numbers that Josh reported as well, is that we are not out of the woods. Indeed, this foreclosure crisis will be with us for years to come, because even though numbers are subsiding, you have a very large number of distressed borrowers right now. And just I would also say, I didn't talk about it here, but we've done some work at the Furman Center showing that counseling really does make a difference, and in helping borrowers, get modifications, and so and those the sooner you can get to a borrower, the more successful the outcome is going to be. And so I guess that's just plea to sort of keep on doing the great work that you're doing, and we've got to figure out ways to get to borrowers very soon.
Yeah, I mean, I could say we need principal reductions, but I don't want to upset
Right.
Jeff. So I'll say a couple quick points. I mean, one is just to recognize that we have in New York, I mean, one of the silver linings here is we have the best network of legal services attorneys and counselors in the country. I mean, it's an amazing network in New York City and around the state, and has really made a lot of headway in really making New York one of the leaders in foreclosure prevention, even as more and more people are in distress. We have a great group of advocates who are pushing back, and so hopefully the funding will stay in place so that great work can continue. And then just sort of maybe a philosophical point, but something to sort of keep in mind as we push together on this advocacy work, just to think of as a way of thinking of the role of banks. The big banks made a huge profit in the run-up to the financial crisis, and again, not to be a broken record here, but we bailed them out in a big way, and we continue to. The banks are the most heavily subsidized industry in the country, and so I think we need to think of in trying to hold banks accountable, that banks actually have an obligation to communities and to the public. That banks are really, that we should think of banks sort of as a public utility. Banks should exist not to leech off the economy, but to serve the economy, and we need to think of ways in which we need banks, but we need banks that are serving the economy in a positive way. And we're owed that as taxpayers, given the amount of the bailout. So just in the way of thinking about our relationship to banks and our advocacy going forward.
The only thing I'd like to add is, in case I didn't get this impression in my introductory remarks, that the housing, counseling, legal services synergy and fusion is so immensely important, and we welcome and applaud and hope to participate in all of this advocacy around increased funding in this area. The only other thing I wanted to touch on, in case we haven't today, I know Mark touched on it in his op-ed today in the New York Law Journal, is the importance of funding for courts as well, which is a serious and parallel issue. That's my plug.
Well, I'd love to give everybody a round of applause for